Ladies and gentlemen, thank you for being part of the People's Commission Case 001SA. On 27 September 1997, Nelson Mandela said, "The true character of a society is revealed in how it treats its children." So what is the purpose of the People's Commission? Where justice is unobtainable for children through the mechanisms offered by government and the courts, then the people have a duty as a society to try assist those children. When it has become clear that many children are denied natural justice by the children's and youth courts in Australia and are subjected to a life of cruel punishment and the deprivation of humanity, then the very core of our society is in question. It has become clear that all across Australia, child protection departments and the children's courts are acting against children, separating children from a parent or parents on hearsay and finger pointing. Could this be considered trafficking, as it appears that the department and courts are facilitating the demands for an out-of-home care multi-billion-dollar industry? And when those parents ask for help from their government ministers, department heads, corruption and judicial commissioners and governors, no help is forthcoming. No one wants to interfere with the business that is the state condoning child removals on a mass scale. Of course, I'll be respectful of the secrecy laws when discussing this and other cases, but you can be assured that these cases are shrouded in secrecy, not for the benefit of the children, but for the benefit of those that have committed crimes against children. So let me get to the first case, 001. There are thousands and thousands of pages relating to the facts of this case, but the department's court strategy is to drown the case with so much paperwork that the court seems to refer to the weight of the paper and not to the facts. The department also has the modus operandi of throwing as much mud as possible, hoping that some sticks to validate their claim of ownership over the child. But in this instance, the facts are very clear. Sexual abuse and exploitation had been substantiated in 2016. Early that year, the child told her grandmother that her father and female associate had taken her to a house and taken naked photographs of her. The grandmother made the notification of sexual abuse, and the department, formerly Families SA, removed the father from the home. The child was interviewed for 1 hour by a CPS investigator, and the detailed narrative that was provided by the child and how she described it and in what context the CPS investigator said was much too reliable. As part of the Families SA and CPS investigation, and because the father had accused the mother of being delusional, she was assessed by a forensic psychiatrist, Dr. JB. His report cleared her of all mental health issues. After the investigation of several months, Families SA and CPS substantiated sexual abuse and exploitation, and that the father had emotionally abused the mother. Their findings were detailed in letters to both father and mother in mid-2016. On receiving the substantiated letter, the father applied to the family court for sole custody. As I've previously published, this is a trick often used to stop further investigations by agencies and to prevent prosecution. However, everyone at this time, including the department and CPS, was supportive of both mother and child, especially in her gaining custody. The child was safe in her hands. I would like to note here that Dr. JB subsequently cleared the mother a second time for the family court trial, plus clearing her of any coaching. But now the crucial part of the case. It was late in 2017, mid-family court trial, and just after the child had turned 8, that an officer, Officer CT, conducted a police interview with the child. In this interview, that lasted well over an hour, the child disclosed in detail sexual abuse, and I will not detail these. It's suffice to say that they were extreme and were forms of child sexual abuse, assault, versions of rape, and death threats. After the interview, the officer told the mother that the child had passed the truth test, told her some heavy stuff, but there was nothing to go on. From this day on, the officer's actions would forever harm the child. After the interview, the officer entered crucial fabrications in her report, writing things like, "The child forgot what she was supposed to say," etc. But the child never said this. It was a blatant lie. It is crucial to understanding this case that Officer CT did not report those late 2017 disclosures to CARL, which is the Child Abuse Report Line. Reporting of a suspicion that a child or young person may be at risk is a requirement by law, especially as sexual abuse and sexual exploitation had been previously substantiated. And this is under Section 31 of the Children's and Young People Safety Act, that if a person suspects on reasonable grounds, they must report that suspicion as soon as it is reasonably practical. And under Section 30, as a police officer, she was obliged to keep that child safe from harm. These new disclosures, along with the past substantiation, would have elevated this to a criminal matter to further bolster CPS and the department's established view that the father was the offender and the mother was the protector, and that the child was safe in the mother's care. The forensic evidence of blood-stained underwear, etc., that had been handed in would have been then tested at CIB. There was no doubt that the child was at risk of harm, especially as the court was deciding on the future placement of that child with the person she claimed abused her. Section 60CI of the Family Law Act requires anyone to report to the court and inform the court any suspicion of risk of abuse. There was more, much more than suspicion in this matter, and Officer CT was in fact concealing these most serious and extreme abuses from the agencies. Was this criminal negligence? Her actions would influence the outcome of all future proceedings thereon. Let us review what laws had been violated in concealing this police interview from the court and from protection agencies. There's Section 241 of the Criminal Law Consolidation Act, impeding investigation of offences, assisting the principal offender to escape apprehension or prosecution. There's Section 243, fabricating, altering and concealing evidence, and Section 14. In Section 14, if the person fails to take the steps that he or she could reasonably have expected to have taken in the circumstances to protect the victim from harm. As Officer CT did not inform the agencies of the police interview, this resulted in the family court judge not having the full facts. And as the judge was not made aware of the serious disclosures by the child in the police interview, the family court was only deliberating the incident of the taking of naked photographs. The police interview disclosures were of a much more serious nature, versions of child rape and death threats. Without knowledge of the extreme abuses, the family court judge, in one paragraph out of a 54-page document, said the 2016 incident of taking naked photographs most likely did not happen. That aside, after a lengthy trial, the orders were delivered in February 2018, where the judge awarded the mother sole parental responsibility, that is, sole custody of her daughter. It was ordered that the child live with the mother and that the child was to go to a therapist with the focus that she was not at risk from being removed from her mother's care. It was clear from all the evidence that the mother was a caring, safe and responsible parent and that the child was thriving and happy. But the court ordered reconnection and visitation with the father. And so here, the mother's story takes on a sinister note. In early 2018, 6 weeks after the family court orders were delivered, the child returned home from the visitation with the father with a significant leg injury. She would finally break down and tell her mother that her father had hurt her. The mother was obligated to report the incident despite knowing the risks of reporting. CARL, that's the Child Abuse Report Line, advised the mother to take the child to a doctor and to the police the next day, and that was in April 2018, which she did. The department, and this is the St. Mary's office of the DCP, the Department of Child Protection, had a strategy meeting with SAPOL, the SA Police, that afternoon. And who was brought into that meeting but Officer CT? After advice from the officer, the investigation of the assault and injury was immediately stopped. The same police officer that had concealed the child disclosures 5 months before was now back in charge of the second investigation, saying there was no need to investigate abuse. There's nothing to see here. So for a second time, it seems this officer was helping the father escape prosecution and was there to deflect the second investigation assault and further sexual abuses. Why did they stop this investigation? When questioned by the ombudsman, they said the intake was closed because this was a family court matter. This was a blatant deception, as they know the family court does not investigate crimes, and that the assault of the child was a state protection matter. The DCP stopped the investigation and never photographed or cited the assault injury. Because the officer had lied, none of the public servants followed the law and the protocols for investigating assault and abuse to a child. It is difficult to fathom Officer CT had personally seen and listened to the child's traumatic disclosures, and after the child was assaulted and harmed, she acted against the child again. The officer would claim the mother has serious mental health issues. At this time, in April 2018, there was nothing in the system that indicated the mother had mental issues. Where did Officer CT attain this knowledge? There's only one source, hearsay from the father. There's only one logical conclusion to her actions, that she was working and colluding with the father. Throughout the second investigation, in 2018, Officer CT continued to conceal the abuse disclosures of the November 2017 police interview by fabricating her entries and reports. And by doing so, she discredited the child and acted unlawfully. And she was writing things like, there is no forensic evidence. There are nil disclosures from this victim. It is disgraceful beyond words, as the officer continued to fabricate her entries. There was forensic evidence, and it seems the officer removed it off the shelves from the CIB. The officer also implied that there were welfare concerns about the mother's care. There could be nothing further from the truth. As the officer was deflecting the investigation, the child was to go back to her father for another weekend visitation. Out of desperation, the child reported to a teacher and asked the teacher for help. The teacher's notification stated that the child made clear disclosures of sexual abuse by the father. The allegations were detailed and specific, and this must have set off alarm bells at St. Mary's DCP office, because it was no longer the mother reporting, it was the child trying to save herself. But what was the officer doing at this time? She was on the phone with both the father and with the principal of the school, trying to force the principal to send the child back to the offender. She was the one that had heard the child's rape disclosures, and now she was the one assisting the offender to get control of the victim. So the wheels of extreme maliciousness began to roll against the child and the mother. To abbreviate the events, after the wound had healed, the child was removed in 2018, less than 3 months after the family court orders were delivered. Contact between mum and child would be from there on 1 hour a week supervised, or even less. This has gone on for nearly 4 years, and it is a brutal and cruel separation. However, now after the mother's continuing challenges, all contact between them has been recently severed. It would take hours to dissect the legal mischief in this case. The distress caused to the child and the mother is unspeakable. It is noted in the reports that the child was grief-stricken, overwhelmed by losing her mother, briefly seeing her and then being taken away each week, and the mother is monitored like a dangerous person, like a criminal. But let me note at this point that the department was given 10 sworn affidavits by family and friends stating what a wonderful and fantastic mother this woman was, and how she brought joy to her child and was so child-focused. But as I would learn, these would mean absolutely nothing. They went into the department's shredder, so to speak, as they did not follow the narrative of the social workers at the DCP St. Mary's. I believe these good parents that have their children ripped from them, and there are thousands of them in Australia, suffer such psychological torture that life becomes a living hell. And so in 2018, the mum began her 4-year battle to regain the rightful custody of her child. Even though she initially cooperated, it seemed there was no way they were going to plan to reunify her with her daughter. What I believed was happening was a backdoor avenue to switch custody of the child. How can we come to such conclusion? Because almost immediately after removing the child, St. Mary's office began preparations to switch custody to the father in reunification court. Knowing the child wanted to be with the mother, knowing that there were multiple reports in the system against the father for abuse, knowing that in 2016 their colleagues had substantiated abuse, and knowing the child was most fearful of her father. I tried to make sense of this misfeasance, thinking it must be a mistake, but at some point I had to admit that this was deliberate and strategic. In the department's own court documentation, it was noted that the department believed the child was at risk of emotional, physical, psychological, and sexual harm if returned to the immediate care of the father. Yet this is what they were trying to do, against their own advice. But more extraordinary events would unfold. Mum and daughter had been apart for over a year, and a psychologist noted that the child would not retract her allegations. It appeared that the only person that had heard the child's disclosures in the police interview was the officer CT herself. The mother was refused an FOI request to obtain a copy of the video, but in July 2019 she successfully subpoenaed the video and learned for the first time the full details of the terrible abuses that had never been known to her or others. After viewing the video, the mother called a caseworker, M, and then Miss W. The team leader refused to watch or consider the video in any way, and having been informed of the extreme nature of the abuses in July 2019, and knowing the child was scared to be alone with the father, this team leader and her team continued with reckless impunity to support the reunification of father and daughter. At the exclusion of the mother, they attempted to switch custody and reverse the family court order via the state court, contrary to all the evidence. It is stunning that she refused to even watch or consider the video, and it took over a year until the mother requested that she be court-ordered to view the video. Maybe a brief mention of the processes of the court is required here. Everything is secret, and the self-represented mother has to fight the might of the state. I cannot think of the youth court as nothing more than a star chamber. Real evidence is set aside, and the court takes over a gaslighting role of the parent in an attempt to bury her in paperwork, lies, misrepresentations, and innuendo. This may sound extreme, but it is not, as I will now show. The logical and legal conflicts of this case are confounding and disturbing. The final judgment from Magistrate K is astounding. It would take several hours to describe the errors in law, the irrationality, or how he acted with bias. How does one come to that conclusion? Well, Magistrate K accepted and put weight on the psychologist that never spoke to the child, had never met the mother, was never provided the full facts. The affidavits of the mother and the notifications of the abuse and the police video were deliberately kept from this psychologist. One has to wonder who would be involved in such professional recklessness. And though the child, now 12, stated to everyone and the magistrate that she wants to go home to her mother, they all defied her wishes. What is most disturbing is that the magistrate gives a free pass to Officer CT's actions. During the trial, the mother pointed to the police officer's failure to do her duty, being the principal catalyst resulting in the DCP removing a child. That everything would have changed in November 2017 had she informed the DCP, the CPS, and the court. But the magistrate's view was that this was unhelpful distraction. How could these contradictions escape logical conclusions? Analysis of just 2 points in Magistrate K's judgment reveals the bizarre irrationality and legal unreasonableness of the outcome of the trial that spanned over a year in court. The first claim is that the child was never abused, and that the mother unconsciously influenced the child to believe she had been abused. That claim contrary to all the facts. But then it becomes more disturbing. In the second claim, having just said that the department have established that the child was never abused, he then states, well, if all or some of the abuses did occur, then the mother reacted dysfunctionally to that. How should one react on learning your child has been abused? In this instance, evidence shows that all the mother wants is calm for her child. On reviewing the judgment, it reveals that the youth court is nothing more than a court of Oyer and Terminer of 1692, where spectral evidence and finger-pointing or suspicion was enough for a death sentence, and in this case commit a crime to a life of purgatory, a life without her child, a life devoid of society and family. During the Salem witch trials over 1684 to 1691 in Massachusetts, accused women were often put to the water test. If she floated, she was guilty and executed. If she sunk, possibly drowning, she was then deemed innocent. Either way, this usually led to death. Today, over 400 years later, this seems analogous to the use of unconsciously influencing or personality reaction, using any suspicion and intangible concepts that have no legal basis. Consider the mother and others only discovered some of the extreme abuses long after the child was removed, and her child has consistently refused to retract her allegations. One has to consider that the latest research presented by the mother as part of her evidence, the study by 4 authors, including Palmer and Milne in 2015, was commissioned by the New South Wales office of the Children's Guardian and noted Australia having the highest reported rate for child sexual abuse of girls internationally at 21.5%, and that false reporting is repeatedly reported as rare as 1 to 1.5%. After considering an expert of 38 years assessed the police video and 100% supported the child, one has to wonder how the magistrate arrived at a conclusion that the child had never been abused. Oh, sorry, he stated in the next paragraph that all abuse may have occurred. One has to consider, too, that the department took the child on false claims and had to invent these claims 4 years after the fact. Their invention, the mother unconsciously influenced these allegations. This is an extraordinary, far-fetched, unscientific, unmeasurable, and unexplainable accusation. There is also the question of social workers falsifying reports. In one instance, they altered a report, the same sentence, to read the opposite of what the child said. The child said she wanted to go and live with the mother. This was altered to say the grandmother, and the claim was then in the report that the child did not want to go back to her mother. Who would act so? Who would act so maliciously against the child's wishes? A doctor, a GP, a researcher, and a trained psychiatrist, and someone specializing in trauma considered some of the documentation in a psychologist's report and listened to a recording of the child. What he wrote in a letter was this: "This is professional misconduct of the highest order, given the 2016 and 17 allegations that would easily reach the threshold for professional misconduct, requiring urgent ministerial investigation. To conclude that family repatriation with the alleged paternal abuser, when the alleged abuse is obviously of an extreme nature, without an appropriate jurisprudence, determination of facts, and flying in the face of 3 years of consistent reporting by the child, who also clearly says they do not want contact with the father, is the grossest level of negligence by a government department I have ever had the misfortune of bearing witness to in a child-related matter." How does one conclude this case? There was deception to remove the child unlawfully from the care of the mother. There is, however, some hope in these cases that are being exposed to the public, because more and more people are aware of the dark crimes in society, and more people are becoming aware of the actions of the child protection departments across the country. What one can say in this instance is that the judgment by Magistrate K is a disgrace. So to conclude, what is the journey for the child? At first she was heard and supported, but after a police officer told her to use her brave voice, this officer hid those extreme abuse disclosures. For speaking out again and again, the child was punished and psychologically tortured when the person she loved most in the world was taken from her. At one point she wrote a secret note to her mum, pleading for her to get her home. This note was forwarded to Minister Rachel Sanderson. For this, she was punished further when the department placed further restrictions on access visits with her mother. The department's claim of guardianship means the child will never be able to get a hug goodnight from her mother or have her at a school play until she's an adult. This child will face lifelong consequences of being alienated from her loving mum. So why did the social workers not reveal all the supportive evidence in the court and go against the child's wishes? This is not the lucky country for thousands of children in a similar predicament, and one can only hope that some brave leaders in government will put their hands up to right a terrible injustice.